Hello, everyone, and welcome to this month's webinar From Policy to Practice, Creating an Impactful Employee Handbook. This free webinar is available exclusively for customers enrolled in our subscription services. I'm Stephanie Blicky, the Product Operations Manager for Personnel Concepts. I'm joined by my co-moderator, Dan Hilfrich, who serves as Personnel Concepts Senior Human Resource Manager.
Hey everybody. So for today's webinar, we're going to discuss a crucial resource that all employers should provide, the Employee Handbook. To support employers in creating and maintaining this essential item, we'll look at best practices and what you should not include as possible topics as well. After a brief discussion, you can consult with our HR expert on these insights during our live Q&A session.
That's right. So in today's webinar, we will explore the following topics related to creating, maintaining, and providing a workplace employee handbook. We'll talk about the purpose of an employee handbook and why you need one, current federal and state laws that dictate handbook content, proper implementation, suggested additional sections, what not to include, and updating and storing materials. And then in the final moments of our webinar, our guest speaker will accept questions and answer them live, providing Personnel Concepts customers with the invaluable experience of engaging with the HR expert on critical issues. Our speaker will offer some key takeaways at the end from today's session, and will engage the audience with poll questions throughout. So speaking of engagement, let's just get started with our first poll. Today's webinar session is heavily dependent on audience participation. To make the best use of our time, we're searching for timely and meaningful questions to present to our guest speaker. So to ensure that we're prepared to fulfill today's hour with helpful content, we want to know, what are you most interested in hearing about today? How to properly implement and distribute a handbook, the current federal and state laws that require specific policy language, what sections and policies might be beneficial to your organization, what not to include in an employee handbook, and you can select all that apply. We'll give everyone a minute to answer. All right, so based on the results, we're kind of across the board here, but it looks like the leader here is federal and state laws that require specific language, and also what not to include, and we'll definitely touch on both of those today. Thank you so much to everyone who responded. So as your Q&A session moderator, I'll direct your questions to our guest human resource expert. Just keep in mind that your questions might be slightly modified to ensure the best outcome for the session. The purpose of this webinar is to provide accurate and authoritative information on the subject matter being discussed. It does not constitute legal advice. The applicability of the tips and laws discussed today may depend on your state, type of business, and number of employees. We recommend working directly with legal counsel and your HR professionals on specific matters pertaining to your business. Personnel Concepts, the webinar hosts, and our guest speaker are not liable for any errors, omissions, or changes in law or advice that lead to unfavorable outcomes.
Thanks for that, Stephanie. So I'd like to welcome Dr. Carrie Nelson as our featured guest speaker. Carrie is an independent HR consultant with 25 years of experience. She enjoys and is passionate about her job of providing fractional HR support to clients across the US and abroad. This consists of policy development, including handbooks, recruiting strategy, compensation planning, employee surveys, executive coaching, management training, and guidance for employee relations and performance management. Before starting her own consulting firm called Anova Resources, Carrie worked as a director and VP of HR in both for-profit and not-for-profit settings. She also served as a board member for the Cambridge Women's Center in Boston and the Humane Society. Carrie has a BA in business and psychology, and a master's in organizational development, and a PhD in industrial organizational psychology. Welcome, Carrie.
Thanks for having me, Dan and Stephanie, and thank you for that introduction. As you said, I'm currently an independent human resource consultant and have worked closely with business owners and human resource professionals on various matters over the years. Many of these involve creating and implementing a legally compliant employee handbook. Today's most important takeaway from everything we discuss is that it's highly advisable and will save employers money in the long run of each workplace, each of you review existing policies within your handbooks to ensure compliance with the latest laws. Along the same lines, hopefully this session will inform employers about other policies they may want to add to avoid possible fines and penalties due to non-compliance.
Thank you, Carrie. We're definitely looking forward to discussing this topic with you. And before we proceed, we just want to make sure that everyone can hear and see Carrie clearly. If you have any audio issues, check the volume on your computer or mobile device. If that doesn't solve the problem, just let us know in the chat and we'll work to improve the audio as best we can.
All right, and before we begin, Personnel Concepts is offering all of our attendees our 2024 HR Record Retention Guide, along with today's slide presentation, equipped for note-taking, which is attached as a handout here in GoToWebinar. At the end of the session, you'll receive a downloadable certificate via email as proof of your attendance today. Also, I wanted to invite everyone in attendance to submit any questions you may have during the presentation by using the Ask Question feature in GoToWebinar. You can also post questions in the chat window. Most questions will be saved for the end of today's session. Still, those relevant to the discussed subtopic will be posed where appropriate. With that, let's get started with today's presentation. Carrie, let's start with the basics before understanding what should and shouldn't be in an employee handbook. First, what is the purpose of creating a handbook and why should employers have them?
Excellent questions, Dan. Let's start at the beginning. So basically, an employee handbook contains information related to a company's HR and payroll policies. It also provides information to employees to help them understand their rights and responsibilities. You'll hear me say that a few times throughout this presentation. It can also include helpful information about a company's history, mission, and values. I also want to mention that throughout the webinar, I'll use the term employee handbook. However, this document can be used for contractors also. So sometimes it's referred to as a team member handbook.
Thanks for the information, Carrie. Now that we know what an employee handbook is, why do employers need it?
The information an employer includes within its handbook is often the most essential information a worker will receive about their role in the company. As an employer, you are legally required to inform your workers of their rights and responsibilities. So let's go through that. Some of my rights as a worker might include EEO protections, which are I will not be discriminated against for my age, gender, or race. I also have the right not to be harassed in the workplace. I might have a right for leave programs, paid time off, and workers' comp coverage if I have an injury. So those are some examples of my rights as an employee. But I also have responsibilities as an employee. So it could include following the dress code, showing up to work at expected times. I might also be responsible for submitting a timesheet at a certain time. A good rule of thumb is that if any action can cause an employee to be disciplined, lose their job, or not be paid on time, the employer is legally and morally obligated to explain it to the employees up front. Including those responsibilities in the employee handbook is the best way to do that.
That's great information, Carrie. I think it's always beneficial to remember why we, as employers and HR professionals, need to provide specific information to our workers. Not only is it a compliance thing, but it also helps keep employees aware of their rights.
Yeah, definitely. This is an excellent spot to ask our audience another poll question. So we want to know, does your company currently have an employee handbook in place? We have yes, and we regularly review it and keep it updated. Yes, but it needs review and update. Or no, we currently do not have a functioning employee handbook. Please select the answer that best applies to you. We'll give everyone a moment here to get those in. This will just kind of help guide our conversation. So it looks like yes, but it needs a review and update is the most chosen answer. So good, you guys are in the right place. Thanks so much for participating.
Yes, excellent. So I'd like to review some guidelines to ensure your handbooks are as up to date and complete as possible. I'm going to review federal laws that everyone must follow, state-specific laws that may vary, and then suggest additional sections typically included in most handbooks.
Excellent, Carrie. Well, let's start at the federal level. Which federal laws or standardized statements could affect our attendees?
Well, first, I want to talk about at-will employment. Nearly all handbooks should mention the concept of at-will employment at the beginning and at the end of every handbook. Every state except Montana allows employers to create an at-will policy. At-will employment is an agreement that employment is for an indefinite period and may be terminated by the employer or the employee at any time. You need to ensure that there's a clear definition of this in the handbook and not just that you're an at-will employer. Some employees may not understand what it means. Now let's talk about equal employment opportunity laws. Those regulations are enforced by the Equal Employment Opportunity Commission. The laws for EEO protections can be seen on your current slide. We'll also be providing a link to that verbiage in the chat window. With the exact level of detail, those words seen on the slide, those must be placed in every handbook because it's a federal law. Additionally, every state where you conduct business may have additional protections that you need to review and add to your EEO policy portion of the handbook. We'll cover those state requirements a little later in the presentation.
Thanks, Carrie. And like she said, the link to that is in our chat window. So if you can't access that, just let us know. Carrie, what about reasonable accommodations and harassment and discrimination prevention? Are those topics regulated federally?
Yes, they are. So let's talk about them. The EEOC abides by certain text when discussing reasonable accommodations. That means every employer must abide by that. That verbiage is now on the current slide, and we'll be providing a link to a more condensed version in the chat window. Your employee handbook should include a reasonable accommodation policy that, in addition to offering reasonable accommodations for disabilities, also makes accommodations for religious practices and sincerely held religious beliefs. You must remember, however, that creating the policy about something like the Americans with Disabilities Act and reasonable accommodations is not enough. You have to clearly define the laws and inform the employees of their rights, but you must also explain what an employee can or should do if they have a question or a claim. This is also important when it comes to discrimination and harassment claims. So I'm going to talk about that next. When it comes to discrimination and harassment, there are lengthy legal definitions for discrimination, harassment, and sexual harassment. It's up to each company to determine how much legal jargon to use to convey the laws properly to your staff and ensure each employee understands their rights and responsibilities. Companies may implement stricter policies than the law requires, but the laws should still be clearly stated. So let's review this in a little more detail. For discrimination and harassment handbooks policies, make sure to explain the laws and protections, the importance of proper conduct, be proactive in what you expect. The process for reporting a claim for yourself or for others. If I know what the process is, I'm more likely to tell you that there's an issue that you can fix. And then an overview of the investigation process, which makes someone more comfortable with filing a claim because they know what will happen next. It should also include a clear statement saying that no one can be retaliated against for good faith claims.
Thanks, Carrie. Is there any other federally dictated information that employers should include?
Yes, immigration and citizenship issues. There's also employee classifications and adherence to the Family and Medical Leave Act, FMLA, depending on your employee size, are also items that employee handbook should address. So let's review those now. So the Immigration Reform and Control Act. Employers might not be familiar with the name of this act, but many employers commonly include the questions for applicants, are you eligible to work in the United States? This question exists because the Immigration Reform and Control Act requires employers to ensure that every W-2 employee on your payroll is legally allowed to work in the United States. This is one of the most common federal laws that are not followed by small employers, and consequently, it's the most fined. This process includes new employees completing an I-9 form and employers inspecting the provided documentation to ensure employment eligibility. Employers must reference this law in both offer letters and the employee handbook for full compliance. Let's also talk about employment classifications. So it's another big topic that should appear in your handbook. When I say employment classifications, I'm talking about conveying to others how each job description at your company is classified, such as, are they an employee versus a contractor? Are they full-time, part-time, temporary? As you know, these designations can affect, among other things, minimum wage, overtime, and tax requirements. So it's important to have it be correct. I always tell my clients that in the handbook, it's important to explain employment classifications in 3 ways. Number 1, define the terms employee versus independent contractor versus temporary employee. You might also want to use other classifications that may apply to your workplace. For example, you might have per diem staff, which is common in medical communities. You might have a separate section for interns, and maybe they get treated differently in some way. If you have a classification, put it in there and define it. This way, all workers will know the category in which they fit. Keep in mind that some laws dictate how these classifications are made, so it's just not up to you to decide. You need to know where they fit within the law. Number 2, once you categorize a job description as a W-2 employee, you need to assign the correct definition under the Fair Labor Standards Act of exempt or non-exempt status and provide information about overtime. Non-exempt job descriptions are paid hourly and are legally required to be paid overtime when they work more than 40 hours in a week. Some states provide additional rules for overtime, such as working more than 12 hours in a day. They might require you to pay overtime in those situations. Exempt positions are typically paid on a salaried basis and are not legally required to be paid for overtime. This is another common area where small employers make mistakes and can be fined. So keep in mind, every position has to be paid hourly unless it qualifies for an exemption under the FLSA laws. And 3, define your company policy and how many hours worked are required to be considered a full-time and benefits eligible employee. This one is not required by law, so it's up to each company to decide this for themselves. But once you make the decision, you need to implement it for everyone. For example, you may say that an employee must work 32 hours a week to be considered full-time. This is important to explain up front because typically full-time staff receive those extra benefits such as paid time off, paid holidays. Make sure that any decision that you make in your employee handbook regarding this is also reflected in your benefits policy contracts. So for example, if you say 32 hours a week is full-time benefits eligible, your medical and dental insurance plans should say 32 hours a week and everyone's going to get it. To avoid possible fines, you need to ensure your benefit contracts matches this policy in your handbook.
All right, and what about the FMLA, Carrie? Should handbooks include reference to that law?
Absolutely, yeah. So I'd like to touch on the federal FMLA first. So this is federal for everyone. Allowing employees to take time off for family and medical leave, it's become a complex and hotly debated topic. On a federal basis, once an employer has reached 50 or more employees within a 75-mile radius, they must begin complying with FMLA laws. These laws do not pay for the approved time off for the employees. However, it offers job protections and requires the employer to provide eligible employees the same or similar positions when they return from an approved leave. I would elaborate further on this, but most states have additional protections on top of the federal requirements. Additionally, many companies offer more protections than the federal government's basic minimum. If you provide more than the federal minimum that's required for FMLA, you do not need to include a federal policy in your handbook because that could confuse people. However, whatever family and medical leave policy your company follows should be conveyed, explaining workers' rights, protections, and the process for filing a claim.
Lots of great information, Carrie. And before we move on, I'd like to encourage everyone in attendance to follow our blog at blog.personnelconcepts.com for labor law news and updates. We're posting regularly about updates in labor law compliance. So we'll put that link in the chat window here. And before we continue our discussion, I'd just like to ask the attendees another poll question to determine how much time we should spend on the next important topic. So which of the following best describe your company's location? So we are only located in one state, we have office locations or workers in multiple states, or my company is international with offices and workers in different countries. So we'll give everyone a moment to answer. This just helps us see how much time we should spend. All right, so it looks like the majority of our audience is only located in one state, but we do have some of our audience that's located in multiple states. So thanks so much for your responses. Carrie, how about we review some state-specific requirements for our audience next?
Yes, great. So keep in mind different states, counties, and even municipalities may have laws that vary on the topics I will discuss. Business owners must understand the laws that apply to their employees and communicate them accordingly. As a note, your primary state is typically where you're incorporated and where you have a bulk of your employees. However, if you open an office or hire just one employee to work in another state, you must comply with the laws of that state for those staffers. The following slides will discuss state laws that should be included in a handbook. The examples in this section are not a complete list of specific state laws that should be added as handbook policies. It's recommended that you consult with legal counsel or human resource consultants at your company as required for more detailed information. So let's start with those EEO protections. So I talked about EEO in the federal laws, but some states have additional EEO protections. It would take pages and pages to list them all, but here are just a few examples of additional EEO protections. Washington State last year now protects caste in addition to race and color. So that had to be added to all the Washington State handbooks. Massachusetts now protects veterans that used to be in the military. California now protects military and veterans, and about 25 other things. So these are just certain nuances that might need to be added. Many states have also passed the Crown Act, which protects employees' natural hair and hairstyles, including braids, afros, curls, and knots. In fact, most states have this law now, the Crown Act. Next, let's talk about meal and rest break policies, because these can vary significantly by state and are required by law. These policies are typically enforced for hourly staff, while some states do not have any specific laws requiring these breaks. Here are some examples of state break policies. In Maine, private employers must allow hourly staff at least a 30-minute meal break for every 6-hour shift. In Nebraska, only certain employees get a 30-minute meal break when working an 8-hour shift. On the opposite side of the spectrum, California meal and rest break laws are so complex that I usually provide my clients with a detailed chart of if-then. You know, if they work 3.5 hours versus 3 hours and 45 minutes, this is what they get. Another important rest break consideration is allowing new mothers to pump milk privately, which might require longer breaks or separate breaks. This is legally required, and the verbiage for these protections could be placed in the break policy or your FMLA policy or your maternity policy if you have them.
Okay. And are there any tips that you might have for employers regarding vacation policies?
Definitely. So employers are not legally required to offer paid vacation time, but if they do, state laws vary based on how it is administered. For example, some states require employers to pay accrued vacation time when employment ends, while others do not. Additionally, many states are also adopting paid sick time requirements. In California, for example, most employees, including part-time staff, must receive some portion of paid sick time. For states that adopted sick time policies, the rules on how much is earned and if it is paid when employment ends varies. No matter the situation though, if your business offers paid sick time, that state required policy must be in your handbook. So now let's talk about leave programs. Leave programs are the most complex and variable laws between the states. These are the most complicated state laws to track and administer properly. These programs might include paid or unpaid leave for an employee's own health or medical reasons, leave to care for a family member, parenting leave, and military leave for myself or for a family member. A couple of states have also implemented bereavement leave requirements. If you only operate in one state, which most of you do, great. If you have a state-run program, it's a good idea to provide a link to that program in the handbook. That way they can maintain their own website with the rules. You should also summarize the benefits available in the reporting process, giving appropriate links for how they can file a claim. Businesses operating in multiple states might want to create a more generic leave policy, instructing employees to contact HR or another designated individual for specific information. Also, many states legally require employers to provide both time off and accommodations for employees who endure domestic violence issues. This information should be placed in your handbook. This is separate from the previously mentioned sections. Next, there's whistleblower protection laws in some states that protect employees from retaliation or harassment for filing internal or external claims of possible company violations. These specific laws vary by state and how they're administered. Generally, covered businesses are required to create a whistleblower policy. Various states have job protections and even require employers to offer some paid time off for jury duty and witness leave now. Some companies on their own, without the government's requirement, offer unpaid or paid jury duty and witness leave. All this information needs to be made available to your employees in your handbook. Along the same lines, most states offer job protections for voting leave. However, this is administered in various ways. Employers should consult with local government entities about what should be included in the handbook in their state and how to inform workers of their rights. Workers' compensation is another one. It's legally required to be provided to most W-2 employees. State laws vary as to when an employer must purchase workers' comp insurance. Sometimes you're required to do it when you hire your first employee. Some states don't require it until you've hired your third or fourth employee, but still affected employees must be informed about this and understand their eligibility and reporting requirements. All of this information should be in the handbook. And finally, some states legally require employers to allow employees to access and photocopy records from their own human resource files. Before adding this information to a handbook, employers need to know what is required of them by law and what is allowed to be stored and shared.
Thanks for that overview, Carrie. Stephanie and I would like to take a moment to remind viewers that just as Carrie is here to help you with help your employee handbook comply with federal and state laws, Personnel Concepts is here to help with workplace poster compliance. If you have any questions about the workplace posters you need or your subscription level, please contact a compliance specialist through our customer service line. The number is now available in the chat window.
Absolutely right, Dan, right? There's stuff that goes on the wall versus in the handbook. So if you have questions about what goes on the wall, ask us. So besides required sections or policies, Carrie, do you have any suggestions for other handbook content?
Definitely. So even though the following topics may not be required by law, including these sections will make an employer's handbook more comprehensive. I'll divide the sections into different topics that a handbook should address. So let's talk about company culture. The following sections and policies should be included to inform employees about the company culture. So every handbook should start with a personal welcome statement. It can be from the CEO, the management team, or the HR department. Something like, welcome to the company. We're so glad you're here. Thank you for being an important part of our team. That's a great way to start a lengthy document like this. Your handbook can also include an overview of the company's history, mission, vision, and values if you have them. A mission statement is your purpose of being. Your vision is a future statement about where you would ideally like to be if all of your goals were achieved. Your values are the company's primary principles in attaining the vision. Most companies also have a code of conduct to remind employees of what is expected of their behavior. Again, it's good to be proactive and talk about what's acceptable, what's not acceptable, instead of just waiting for what's wrong. Most companies also should have a conflict of interest, especially when it involves employee dealings with a competitor or if another job is affecting an employee's performance at your company. Those are reasons to have a conflict of interest policy. A dress code or uniform policy is also important too. I've had many clients who say, I don't need a dress code policy. And I always say, what if they come to work or come to a Zoom meeting with a swear word across their shirt or some other offensive remark? In those situations, it helps to have a dress code policy of what's going to happen. They're going to go and change, or they're going to get paid for their time, things like that. And also a computer, email, or IT policy discussing the ownership of work email accounts, electronic equipment, and voicemail services. And there should be no expectation of employee privacy in these things. So other company culture-related policies might include a company social media policy. What can employees say on the internet about the company or your clients? What are they not allowed to say? especially when it comes to client privacy. A remote work policy if you have remote workers. What are the rules around that? A grievance policy is also important. It goes over the internal process for stating concerns. If your employees don't know who to go to within the company with a problem, they might go outside or onto social media to vent their concerns. You'd much rather have a clear process for who they can go to internally. You might also have an expense report and mileage policy. You know, if I went on a business trip and I have to submit those receipts within 14 days, hey, tell me up front so I can abide by that. You might also want to have a gift policy that clearly sets expectations for what gifts employees can and cannot accept.
Thanks, Carrie. So 2 topics I think that have come up in past webinars are payroll and attendance issues. Would you recommend that employers include information about those topics in the handbook?
Yes, I think those are 2 essential items to include. So when it comes to payroll and attendance related information, I suggest that employers include the following information. So hours of work, very important. Core hours. Now, core hours are if you allow flexibility, but you want everyone to at least be available at certain hours, like 10 to 2 Pacific time, Monday through Friday, you must be available. If that's the case, put it in your handbook. Also, timekeeping and payroll policies. Do I need to do a timesheet? Do I need to request time off online or via email? Those things are important to put in there. An attendance policy discussing what is considered being on time and what's considered being late. If I'm 5 minutes late, am I going to be written up? If that's the case, please tell me up front because I deserve to know. And I'll be in more adherence to the policies. Reporting out sick or running late should also be covered. So a holiday policy that includes a list of the days when the office is closed and if they are paid or unpaid for employees. That's also good to have. So let's talk about performance and termination. I think being transparent about your company's performance and termination policies in a handbook is also very important. Consider adding the following if you don't already have them. So 1, a performance evaluation policy. This is if you do performance evaluations, let's say you do them every June, put that in the handbook. And your employees would love to know that. If you have a specific form you're going to use to rate them with too, show it to them way beforehand so they have time to comply, do a good job. Your company should also have an established progressive discipline policy. So what happens when something's wrong? Is there a verbal warning, written warning, final warning? The company can skip steps and you put that in the policy, but it's good to give a general framework of how you manage discipline. If your business requests employees to follow a procedure when resigning or being removed from their position, so for example, if someone is going to resign and you want them to give at least 2 weeks notice, they have to return company supplies on their last day of work, things like that, you should include an employment separation policy in the handbook, which is highly recommended.
Great. Carrie, workplace safety has recently become a significant topic of conversation. What could an employer include in their handbook acknowledging that topic?
Yeah, that's another hot topic. It's a great one, very important. An employee handbook could also include statements acknowledging the company's commitment to workplace safety. So for example, let's just start with we are committed to safety. Every company should have this and it's unique to your culture. It should be proactive in nature and also requests employees to report safety violations that could cause an injury. You might need to have a smoke-free workplace policy stating that smoking and vaping is prohibited indoors and can only occur in designated outdoor locations. And you might also want to have a drug and alcohol-free workplace policy that at a minimum states that employees cannot come to work impaired under any substances. A summary should also be included in your handbook if you have any pre-employment, random, or reasonable suspicion drug testing policies. So finally, I think additional policies involving company hiring and onboarding procedures could be added. So these include a summary of the company's employment verification or background check procedures. Also an introductory period statement. These used to be called probationary periods. They're now called introductory periods. These dictate a specific time period when a new employee is considered in training.
That's all great information for employers to remember when they create or review their handbooks. And I do want to ask, if an employee is provided a handbook and they still break the company policy claiming ignorance, no, I didn't know, how can an employer prove that the employee knew about the policy?
That's another excellent question, and it leads to what I think is the most critical part of the employee handbook, the acknowledgement form. So the receipt of handbook acknowledgement form is a page that the employee signs and returns. The form should state that the employee received the handbook and understands they are responsible for adhering to the rules. You shouldn't say to them, you promise to read this cover to cover, because they probably won't. The form should also reiterate the company's at-will policy. Remember earlier I said at the beginning and at the end, reinforce that again. This is the page they signed, so they're going to look at this one the most, and explain that the business can change policies anytime. So the signature can be physical or digital depending on how the form was provided. And if a new handbook is issued, so if you've had one in the past and you're just implementing an updated one, it's important to have the date of the latest version on the associated acknowledgement form, so you have a record of what version the employee received and when they agreed to follow it.
You make a great point, Carrie, especially regarding the dating of the acknowledgement forms. As we start winding the webinar down, I think it's important to address a crucial topic, which is what not to include in the employee handbook.
Yes, absolutely. It can be very easy to get carried away when creating or updating a handbook. You want to include everything in the world you possibly want to tell an employee. However, as was said at the beginning of the webinar, an employee handbook should contain information related to companies' HR and payroll policies. It should not include things like job descriptions. Job descriptions are great to have as separate documents. They're often changing and evolving as the company grows, so they don't belong in the handbook. Operations procedures, so steps on performing individual job tasks, do not belong in the handbook. Salary information, including information or potential future raises or bonuses, should not be included in the handbook. You can't really promise those things anyway. Don't back yourself in a corner. Things like elective benefits that they can pay for if they'd like, such as medical and dental insurance, those things usually change annually, so those don't belong in the employee handbook either. Again, great to have, but keep it separate. And the final thing I would say is specific employee names should not be included in a handbook. If you need to refer to someone, refer to their job title instead of their name, as individuals may leave companies.
Carrie, is there a rule that employers should follow as to when they should implement their company's employee handbook?
Yes, well, my easy answer is to be safe and provide a transparent and open working environment. Employers should create their employee handbook when their first W-2 employee is hired. I do know, however, that some companies have waited until they have a certain number of employees before building their handbooks. I also think it's safe to say that some companies, no matter how long they've been established, still don't have an employee handbook. My answer to those businesses is to build their employee handbook now. Not informing employees about their rights and responsibilities puts the company in jeopardy of lawsuits and governmental fines.
Thanks for clearing that up, Carrie. What should the process be when updating the handbook?
Yes, so it's a good idea for employers to assign someone internally to maintain and update the handbook. I also recommend that that person review the laws affecting their company at least at the beginning of every calendar year, which is typically when new laws are released. Every time a new rule is implemented or an existing one changes, it should flag that internal handbook should be updated. You might not send it out every single time a couple words change, but you should have a running handbook that's ready to go with everything. When you are ready to implement a new or updated handbook, I recommend these following best practices. 1, announce the approved update to all employees via email or in writing. When you do this, make a list summarizing what was changed. Don't make them hunt for it or wonder what the changes were, because most people, again, won't read it cover to cover. Make a list. After you announce it, conduct a company-wide meeting highlighting the important rights and responsibilities that are in your handbook. That's a great way to bring people together too. Also allow a Q&A session if time allows, or have a way for people to ask questions. 3, after you have your all-employee meeting, have a second meeting with managers to explain what they can do to enforce the new or updated rules and the policies. It's a great idea to have periodic management training anyway, and it's a great way to bring the management team together when you have a new handbook and you want to talk about things like attendance or holidays, things like that. And then 4, if possible, release the handbook through a payroll system internal portal, or other digital means to allow for electronic signatures. That makes it so much easier on you. Many payroll systems allow for this without you having to pay for an upgrade. Otherwise, make sure to track and store the signatures received on physical or paper copies.
Carrie, you just mentioned storing signatures received on the handbook acknowledgement form. Are there any record-keeping rules that our audience needs to know about?
Yes, thank you for bringing that up. So each signed employee acknowledgement form must be stored and saved, whether they were received digitally or physically. If a handbook was updated and distributed multiple times, each round of those forms should be dated to correspond with the date the handbook's release, and those stored separately. So you would never want to throw out an old acknowledgement form when you put the new one in, because you still want a record that there were past rules that they needed to follow. There are many reasons why proper record keeping of the acknowledgement form is needed, the least of which may be to clarify rules or to reiterate performance coaching with an employee. And I say, hey, you signed it, here's the date, here's the copy of your form. Another reason for record keeping is to challenge possible unemployment or other possible legal claims. A terminated employee may claim they were unaware that what they did was a fireable offense. So however, a signed handbook acknowledgement form could prove otherwise.
Thank you, Carrie, for talking with us today about creating and maintaining impactful employee handbooks. I want to remind our audience that the 2024 HR Record Retention Guide white paper is available as a download in today's presentation, just expanding the conversation regarding what documents employers should retain and for how long.
All right, and before we move into our live Q&A session, we have one last poll question we'd like to ask our audience. Would you be interested in attending future webinars on the following topics? How to perform workplace harassment investigations, best practices in creating and implementing an emergency action plan, how to maintain workplace privacy and proper cybersecurity, or I'm not interested in any of these topics. Please select all that apply, and we'll give everyone a moment to answer. So it looks like we have a lot of interest in all of them. How to perform workplace harassment investigations, creating and implementing an emergency action plan, and how to maintain workplace privacy and proper security. Thank you for your responses.
All right, so we've made it to the Q&A session. So in today's session, I just want to encourage everyone in attendance to submit questions using that question feature and go to webinar. You can also ask our webinar staff just using the chat window. So we'll do our best to get through the most relevant audience questions throughout today's Q&A session, but all answered questions will be submitted to Dr. Carrie for responses and sent out to you via email. So if you don't feel like you got an answer, just keep sending them throughout the end of the presentation and they'll get emailed to you. So with that, let's just dive in and look at the first question. We do put our questions on the board here for reference. So can you offer any insights or recommendations for businesses operating in states with varying employment laws and regulations? Should we create alternate versions of the handbook or add state-specific info at the end, like an appendix?
That's a great question, and a lot of companies struggle with that. Yes, so I'd say if you operate in multiple states, first, you have to decide internally. Let's say you have 10 employees in Florida and 10 in California, and the ones in California are legally required to get paid sick time. It's up to you. It's certainly much easier to decide to just offer those same benefits to everyone. If you do that, you just need one handbook. It gets very complex when you're in multiple states. So you could create a sort of addendum and have a core handbook and take out PTO or take out holidays or take out leave programs, put those in a separate addendum and then say, oh, here's your handbook, you're a Florida employee, here's a Florida addendum. So you can, but it is complex to manage. And I recommend, if possible, having standard policies for everyone.
Recommendation. Thank you, Dr. Carrie. Let's see here. Let's get another question on the board. We'll just keep going through them. And if at any point you feel like you still have a follow-up question, go ahead and put in the chat. We can get it answered later. We are clinics staffed solely by volunteers, a few of whom are paid a small stipend. What must be included in a volunteer handbook? Is it any different than an employee handbook?
Another good question. Well, I'm going to step back. Some of these questions I'm going to step back. Let me answer this in two ways. Make sure you're classifying your volunteers properly. hate to break it to you, but you might be legally required to refer to them as employees and pay them at least minimum wage. So you can research the laws or contact a lawyer in your state to make sure they're classified properly. That's number one. Number two, yes, just like I said in the beginning, how contractors could also be applicable. You can have one handbook for both, but when you do that, I would clearly specify which laws are for W-2 employees only and which are rules you want your volunteers to follow. So that's really up to you. You can have one handbook where you specify each section, or you can have two separate handbooks. So for example, your dress code, your code of conduct, your policies on expense reports, you would still want your volunteers to adhere to those. So yes, you definitely want to have something for them, and you can do it either way you want.
Thanks so much, Carrie. Excellent answer. Let's go to the next question. We'll get it on the board here. Is there a template for handbook addendum acknowledgements? What happens if the employee refuses to sign the handbook acknowledgement form? And can two witnesses sign off that the individual received it in case of refusal? Three-parter.
Yes, a multifaceted one. It's funny, I review handbooks regularly, and the acknowledgement form is often different. It's you can Google it. A lot of these things, I'll say you can Google it, find one online. Again, refer to an employment attorney in your state to make sure it has all the requirements. But it basically is reminding you of the at-will policy, making sure they understand that they have to abide by these policies. But it is, in my preference is signing the handbook is part of your job. If you don't sign the handbook, I would not continue to employ someone if they're not agreeing to my policies and procedures. That's why it's usually done on their first day of work. If they have a question or if they have an issue, I would listen to them. Maybe if there's something in your handbook that's not right or against a current law, that's the only reason I could think of where they would refuse. But other than that, I would say your employment is contingent upon you acknowledging receipt of this handbook.
Thanks so much, Carrie. We'll get another question on the board here so we can get through as many as we can today. Let's see. One more on the board. If not, maybe somebody can. Oh, here we are. Can you request a review and signature from employees on a yearly basis, or should I only request it after updates are made?
Oh, yeah. I love this question. So yes, you can certainly say, hey, there's no changes in our handbook, but this is a reminder of our policies. So first, yes. Two, if they're not following the policies, I do recommend some kind of meeting or training, whether it's online or in person, or even department-specific trainings where you're discussing what policies they might not be following. And wait, so did I answer all that? On a yearly basis, should I only request it? Yeah, no, and so you can update, you can do it anytime. Also, if there's a particular rule that people aren't following, you can just send that out. If the attendance policy is not being followed, this is a common one. I just did this for a client the other day. You say, hey, everyone, this is a reminder of our attendance policies. This is a section from our handbook. Please let me know or let your supervisor know if you have any questions. So those are some proactive measures, but the answer is yes, you can send out the handbook without updates.
That's definitely good to have those reminders there. We'll get the next question on the board here. Can we include a policy about personal cell phone use on the job?
Yes, absolutely. That's a very popular one too. I would include that probably in your code of conduct. But if you are having a specific rule, like if it has to go into a locker, if it can only be during break time unless there's an emergency, yes, create a policy, put it in your handbook. Keep in mind, I do say, don't make it too strict. If you have young kids and they need to call if there's an emergency, you're their emergency contact. I wouldn't, fire someone the moment they're on the phone, but create some general rules. And again, reinforce it. If a manager sees someone breaking the rules, they should coach them on the spot and not just wait for when you're about to send out the policy reminder.
Yes, definitely. Thanks, Carrie. All right, let's get another question on the board here. Is it okay to have a summary of a policy in the handbook and include a link to the full policy with all the details to make the handbook more digestible?
You can do this, yes. However, I find it is much more difficult to administer that way. You're going to have a bunch of different policies in different places, and a lot of your policies actually reference other things, like your leave program might involve your vacation policy. There's a lot of things that can be related, so it's nice to have them all in one document. When you change something, you can kind of review the whole thing. Oh, I got to change this, I got to change that. One company I work for recently changed to a 4-day work week. When they changed to a 4-day work week, I had to change about 7 different sections of their handbook, including the holidays. They're not going to get Friday holidays anymore if they're not working on Fridays. PTO, 1 week of PTO is 35 hours, not 40. So I strongly encourage people to keep it in one document. If you can find an administrative way of keeping it in one document internally and communicating it as separate, that's fine, but you still need one acknowledgement form confirming that they have access to everything. So I hope that answered the question.
Yeah, I think that makes sense. Kind of one thing hits another, so it's good to have them there. All right, we'll get another question on the board here. Would it be advisable to include Affordable Care Act standards for employee eligibility for medical insurance into the handbook?
It depends on what you mean by that. I've managed this when it was new, when it was coming out, as it's changed. If it's something, I can't think of a reason it would, but I would put this in a benefit summary. So when I said your medical, dental, things like that, you wouldn't want to put in a handbook because it changes. You definitely should have a separate document that clearly defines all your benefits and what they even COBRA, things like that, and then update it every year when you have your open enrollment. That separate document is also fantastic while you're recruiting new people. You can say, here you go, here's all our benefits and what you pay versus what the employer pays. So I think in general, I can't think of a reason for it to be in there, but feel free to follow up if there's a more specific question about what you think might need to be included. And I can advise as much as I know, or I can, refer you to an employment attorney in your state just to make sure.
Thanks, Carrie. So you're saying there's the handbook, there's the benefits book, and then there's what not to put in either, probably. So feel free to go back to those sections of the webinar for reference. Look at another question on the board here. We still have a few minutes for asking questions. Keep them coming. Like I said, if she doesn't get to them, we will have the answer sent out via email. So when discussing discrimination, you mentioned good faith claims. What are your good faith claims?
Yes, excellent question. So a good faith claim is basically an honest claim. You can't expect all of your employees to know all of the laws, but I'll give you a common example that I have come across. If one employee asks another employee out on a date and that employee says no and nothing further happens, that does not meet the legal definition of harassment. I have sometimes had people come to me and say, someone asked me on a date, asked me out for coffee. I think I was harassed. And I have to walk them through the process, asking them questions, explaining the law, explaining it's not illegally, if that's all that happened, it doesn't meet the legal definition. That is a good faith claim. They're just asking the question. If someone made up a lie and tried to just get someone in trouble that they don't like, that's a bad faith claim, and that is disciplinary in nature. That person should receive a warning or possibly termination if they're making up lies to get someone in trouble.
Thanks for defining the difference for us there. All right, let's get another question on the board here. What common things might be included in a company's definition of conflict of interest?
Yes, so I'll give a little more details into this. I'd say anything that, if I'm an employee of the company making decisions about the company that benefit me or my family personally, that's a conflict of interest. So what's an example? Let's say my sister owns a landscaping company and she's promised to cook me dinner every Sunday if I hire her at my company to be the landscaper, even though she charges more than my current vendor, So something like that would be a conflict of interest. Anything that involves personal gain. It can also involve if I have a second job, if an employee has a second job that conflicts with my job, like it's the same hours, I'm falling asleep because I'm tired from the old job, it's affecting this one, that would be another conflict of interest. This is one that I do recommend too. You can Google it, find sample conflict of interest, because this is something that evolves as your company evolves. There may be other things that you want to add over time as things occur.
Okay, thanks. Here we have time for another one, I believe, maybe one or two. Let's get a question up on the board here. Should our drug policy specify opioids and marijuana use separately? Do you use the word cannabis?
Good questions too. Yes, I took a couple of classes with law firms when some of these laws came out. So I would recommend having one policy, and what you refer to it, I would say whether you say marijuana, cannabis, I'd say use whatever word is most common in your area. Sometimes it's, colloquial words that are used. But the way I've been taught to approach marijuana is think of it like alcohol, if you're in a state where it was legalized. So alcohol is legal. I am allowed to drink alcohol, but I'm not allowed to come to work drunk. So that's how you should see it. That question is usually around states that have legalized marijuana. Even if it's legal in your state, you can't come to work impaired. The one thing I'd say on the flip side, you have to be careful of drug policies, only because if I have a prescription from my doctor that doesn't affect my ability to do my job, that's okay. So you can't say no drugs are allowed. You really have to have a detailed policy explaining what's not acceptable and define what will happen here. And with this too, if you have a drug testing policy, if you think someone's impaired and you're going to bring them to a place to be tested, you should put that in there too, to say if we have reasonable suspicion, this is what will happen.
Some good guidance. Thanks so much, Carrie. We'll do one more question here. We'll put it on the board. Are there any legal requirements that businesses should be aware of when outlining employee dress codes in the handbook?
Yes, I love this question too. I change a lot of dress codes because of this. Go back to the EEO, go back to your EEO and look at those things. Are you violating in any way someone's race, religion? So I've seen handbooks that say you can only have neutral hair color, neutral shoes, it's like, what does that mean? So one, stick to the facts. What are facts that are related to the business? So as a flip side, you can't wear flip-flops at some companies because it's not safe. You might be in an environment where they can trip and fall, something. So that's a business reason. If it's a personal reason, you shouldn't include it, or if it could possibly offend someone. So having a correct dress code is important to make sure, again, you're not offending anyone's race, religion, things like that. So even as a Muslim, if I was a Muslim woman and wanted to wear a hijab, some companies have to amend their policy to allow that, because that's religiously protected. So keep that in mind. And again, ask if you have the question. Ask a lawyer in your state, ask an HR person, make sure your policy is proper.
Great advice. Thanks so much, Carrie. So unfortunately, we have run out of time, but all of the unanswered questions will be emailed to Carrie, and her responses will be sent to all attendees in the coming days. Thanks so much for everyone who submitted questions for the session, and special thanks to Carrie for taking the time to answer them. If you still have any last minute questions, please continue to submit them using the Ask Questions function or in the chat window. And I want to remind all attendees that you also have access to our 2024 HR Retention Guide and today's slide presentation, which are attached as handouts here in GoToWebinar. Carrie, can you please leave us with key takeaways from the information that we discussed today?
Yes, there are a few things I'd like our audience to think about and remember from today's discussion. I know it was a lot. But one, when creating and updating your handbooks, consider and include the federal and state laws that may apply to your business. Remember that the company's size sometimes dictates what federal laws you must follow. At the same time, an office or working location can affect state laws that you must comply with. Two, be sure that your handbook only includes company policies pertaining to HR and payroll. It would be best to exclude anything that could change in the near future, such as elective benefits, job descriptions, pay scales, any promises of future raises or bonuses. And three, finally, consider putting a plan that assigns one individual of responsibility for updating your handbook annually to ensure it includes current laws and company policies.
Thanks, Carrie, for these takeaways. So before we end today's session, I'd just like to remind everyone that attendees will receive a follow-up email with a certificate as proof of attendance and a recording of today's webinar.
All right, this concludes today's webinar. Thank you so much for attending our presentation. We hope you found the information helpful in assisting you in creating and maintaining an impactful employee handbook. Thanks again to Carrie for being our guest speaker. We look forward to continuing to work with you, Carrie, in future presentations.
Thank you so much.
And if you enjoyed today's webinar, we invite you to view past webinars on demand within Personnel Concepts Digital Workplace Compliance Library. Simply click the link on the screen and log in using the email address associated with your account or your customer account number. So to all of our attendees, thank you for choosing Personnel Concepts as your provider of workplace compliance solutions, and have a good afternoon, everyone.
Bye.